Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and I am back again with another video on the Companies Act 2013. So we will be continuing with the Companies Act today. This is going to be our last session on this topic, right? So I have been stressing on this point that this topic, this is very vast. If you start going through each and every chapter that has been mentioned in your act, in that way you will never be able to finish this topic in time. So please make sure that you go through only those topics which can be asked in your syllabus, right? You don't have to go through each and every chapter, you just have to go through the important chapters. So for that you also need to make sure that you go through each of these questions that we are doing here. This is our fourth video on the Companies Act, so you need to go through each and every video that we have posted on the Companies Act, right? So let's start now. Before I start, I would like to tell you that EduTap has come up with two courses for your phase 2 examination, the first one being the test series. Now that your exam is approaching, what you need to do is, rather than now only studying the bare acts, you have to start practicing. You have to give mock tests. So please make sure that now you start practicing and you start attempting tests so that you can understand that where you stand, right? So the first feature here is the chapter wise test. So this course, this includes chapter wise tests. For example, in IPC, in CRPC, in Companies Law, all these acts, they have been divided into different chapters, right? So you get test for each and every chapter that has been mentioned in your act, right? So what you can do is you can prepare for one chapter and after that simultaneously you can attempt one of these tests. So that will be very helpful for your preparation. Then it includes full length test with evaluation. Since the descriptive portion has been added by SEBI for the first time, what you need to do is you need to attempt these full length tests. With this you get to test your knowledge, and at the same time for the descriptive portion our experts are going to check your answers, and on the basis of that they are going to give you necessary feedback which will help you in understanding that where you need improvement, right? So this full length test with evaluation is very helpful for you. Please make sure that you avail this, and you also get one-on-one mentor support. And the second course is the live crash course. The live classes, they are already been conducted, and the classes which have already been conducted, you can get the recorded sessions of those. So if you want, you can take these courses and you can watch the recorded sessions. That is going to be very helpful for you, because all the important topics, all the important questions, they have been covered for each and every subject. They have been covered in these classes, right? Then the second feature is the short notes. Short notes come in very handy when you are preparing for your descriptive portion, right? So you can prepare your descriptive portion with the help of these short notes, and that will be checked by our experts and they will give you the necessary feedback which is required. Then all the features of the test series are also included in the live crash course, and you also get one-on-one mentor support. So all your doubts, all your queries, they will be clarified, they will be cleared by our experts, right? So please make sure that you go through both these courses and you avail our offer which is going on right now. If you want to avail it, you can refer to the link in the description below, right? So now let's start with our lecture. Question number 1. As per section 173 clause 4 of the Companies Act, every officer of the company whose duty is to give notice for the meetings of the board of directors under this section and who fails to do so shall be liable to a penalty of dash rupees. So the answer to this question is option C, that is 25,000 rupees, right? Let's read it. First of all, they are talking about the meetings of the board. This I have told you that whenever they are talking about the meetings of the board, they are talking about the meetings of the board of directors. And wherever you read the term journal meeting, that is the meeting of the members, that is the meeting of the shareholders, right? So this we are talking about the meetings of the board, that is board of directors, that is the meeting of the directors, right? So this is meeting of the board of directors. Every company shall hold the first meeting of the board of directors within 30 days of the date of incorporation. So after the incorporation of the company, within 30 days, the first board meeting has to be conducted, right? So every company shall hold the first meeting of the board of directors within 30 days of the date of its incorporation, and thereafter hold a minimum number of 4 meetings of the board of directors every year in such a manner that not more than 120 days shall intervene between 2 consecutive meetings of the board. And after that you have to conduct at least 4 meetings every year, and in such a manner that more than 120 days gap cannot be given between 2 consecutive meetings, right? So you have to conduct 4 meetings, 4 board meetings in a year, right? Minimum of 4 meetings. Every company shall hold the first meeting of the board of directors within 30 days of the date of incorporation, and thereafter hold a minimum number of 4 meetings of its board of directors every year in such a manner that not more than 120 days shall intervene between two consecutive meetings of the board, provided that the central government may by notification direct that the provisions of this subsection shall not apply in relation to any class or description of companies or shall apply subject to such exceptions, modifications or conditions as may be specified in the notification. The participation of the directors in the meeting of the board may be either in person or through video conferencing or other audio video means and may be prescribed which are capable of recording and recognize the participation of the director, of recording and storing the proceedings of such meeting along with the date and time, provided that the central government may by notification specify such matters which shall not be dealt with in a meeting through video conferencing or through other audio visual means. So some important topics they have been mentioned by the central government. For example, making of the prospectus that you cannot do through audio video means, right? So let's read this again. Provided that the central government may by notification specify such matters which shall not be dealt with in a meeting through video conferencing or other audio video means. Provided further that where there is a quorum in a meeting through physical presence of the directors, any other director may participate through video conferencing or other audio visual means in such meeting on any matter specified under the first proviso. A meeting of the board shall be called by giving not less than 7 days notice. So at least 7 days notice has to be given in a board meeting, right? So a meeting of the board shall be called by giving not less than 7 days notice in writing to every director at his address registered with the company, and such notice shall be sent by hand delivery or by post or by electronic means. Provided that the meeting of the board may be called at a shorter notice to transact urgent business subject to the conditions that at least one independent director, if any, shall be present at the meeting. So if you want, you can conduct a meeting, can conduct a board meeting which is related to an urgent business by giving a shorter notice, less than of 7 days, right? But the condition is that at least one independent director has to attend that meeting. If you have independent directors in your company, at least one of those independent director, he has to attend that meeting for which a shorter notice period has been given, right? Provided further that in case of the absence of the independent directors from such a meeting of the board, decisions taken at such a meeting shall be circulated to all the directors and shall be final only on the ratification thereof by at least one independent director, if any. So for example, you have independent directors in your company but they could not attend this meeting for which a shorter notice was given, right? In that case, what you have to do is you have to circulate that decision that has been taken in that meeting to all the directors, and at least one of the independent director, he has to ratify that decision, then only it is going to be made valid, right? So circulated to all the directors and shall be final only on ratification thereof by at least one of the independent directors, if any. Every officer of the company whose duty is to give notice under this section and who fails to do so shall be liable to a penalty of 25,000 rupees. This was the question. One person company, small company and a dormant company. This we have already covered, that what is a one person company, what is a small company and what is a dormant company, shall be deemed to have complied with the provisions of this section if at least one meeting of the board of director has been conducted in each half of a calendar year. So they are talking about the calendar year and not the financial year. So each half of a calendar year means 6 months. So one meeting has to be conducted every 6 months, right? So in each half of a calendar year, and the gap between two meetings is not less than 90 days, and the gap between the two meetings, two consecutive meetings, it cannot be less than 90 days, right? Provided that nothing contained in this subsection and in section 174 shall apply to the one person company in which there is only one director on its board of directors. So where there is only one director, in that case you need not to conduct these meetings, right? Alright, moving on, question number 2. When a board meeting of the board could not be held because quorum was not there then. So the answer to this question is B. The meeting stands adjourned and the next meeting and shall take place on the same day at the same time and place in the next week, subject to it is not a holiday. Let's read this. So this I've already told you quorum of the meeting. What is quorum? Quorum is the minimum number of members that are required to validate a meeting, right? So the quorum of a meeting of the board of directors of a company shall be 1/3 of its total strength or 2 directors, whichever is higher. So either it is going to be 1/3 of the total strength of the directors or it will be 2 directors, whichever of these is higher, right? And the participation of the directors by the video conferencing or by other audio visual means shall also be counted for the purpose of quorum under this subsection. The continuing directors may act notwithstanding any vacancy in the board. So the continuing directors, if there is any vacancy in the board, the continuing directors, they can work, they can function in the normal course. The continuing directors may act notwithstanding any vacancy in the board, but there is a condition, but if and so long as their number is reduced below the quorum fixed by the act for a meeting of the board, the continuing directors or the director may act for the purpose of increasing the number of directors to that fixed for the quorum or of summoning a journal meeting of the company and for no other purpose. But in case the number of directors, the number of continuing directors, they are reduced below the number of quorum. For example, the quorum was 3 directors and now the continuing directors are only 2. In that case, the continuing directors, they will only play 2 roles. They are given only 2 functions in that case. What will be these functions? First of all, it will be their duty to increase the number of directors to reach the quorum, to at least reach the number of directors as are mentioned in the quorum. Or the second duty would be to summon a journal meeting, right? So these will be only the 2 things that the continuing directors, if their number is decreased below the number of the directors that are mentioned in the quorum, if their number is decreased, so then in that case only these 2 purposes they can do and they cannot transact any other business. That is why they have written and for no other purpose. Let's read this again. The continuing directors may act notwithstanding any vacancy in the board, but if and so long as their number is reduced below the quorum fixed by the act for a meeting of the board, the continuing directors or director may act for the purpose of increasing the number of the directors. Their first duty is to increase the number of the directors to that fixed for the quorum so that they can reach the quorum, or of summoning a journal meeting of the company and for no other purpose. Alright. Where at any time the number of the interested directors exceed or is equal to 2/3 of the total strength of the board of directors, the number of the directors who are not interested directors and present at the meeting being not less than 2 shall be the quorum during such time. So if in case the number of the interested directors they are equal to or they increase than 2/3% of the strength of the board of directors, in that case all the other directors who are not interested, that will be taken as quorum, but provided that it cannot be less than 2, right? So who are interested directors which have any type of interest in the company? For example, they can be the CEO, or for example they have more than 2% of the shareholdings in the company, or for example they are the promoter. So any such person who has any interest in the company, any director who has an interest in that company, they are termed as an interested director, right? For the purpose of this section, interested director means a director within the meaning of subsection 2 of section 184. Where a meeting of the board could not be held for the want of quorum, where the quorum could not be reached, then unless the articles of the company otherwise provide, the meeting shall automatically stand adjourned to the same day at the same time and place in the next week, or if that day is a national holiday till the next succeeding day, which is not a national holiday, at the same time and place. So basically this meeting, this cannot be held on a national holiday. An explanation says any fraction of a number shall be rounded off as 1. Total strength shall not include directors whose places are vacant. Now when we are saying the total strength of the directors, it is going to exclude the directors, it is going to exclude the seats of the directors which are vacant, right? So this is total strength shall not include the directors whose places are vacant. Alright, I hope you are clear with this also. Moving on, question number 3. If director violates either the conditions discussed in subsection 184(1), that is, he does not disclose his interest in any company or association in timely manner, then he can be given following punishment. So the answer to this question is B, fine of 1 lakh rupees. if director violates either of the conditions discussed in subsection 184(1) or 2, that is, he does not disclose his interest in the company or association in timely manner or does not disclose the nature of his interest in the company, then he is liable to a penalty of 1 lakh rupees. Question number 4. Which of the following is true? Resolution by circulation is passed when the details of the resolution to be passed are drafted and sent to the registered address of the directors and their approval is taken. As per section 176 of the Companies Act 2013, the actions or the decisions taken by the director when he was in office would not become invalid just because it was subsequently noticed that his appointment was invalid by the reasons of any defect or disqualification. So the answer to this question is D. That is, both 1 and 2, they are correct. So both these statements, they are correct. Resolution by circulation is passed when the details of the resolution to be passed are drafted and sent to the registered address of the directors and their approval is taken. So basically, if a decision has to be taken and it is related to a small business for which a board meetings need not to be called, for that there is a provision that they can pass that decision, they can come to that decision by circulation. What is the circulation? They can do what? They can draft that proposal and send to each and every director of the company and they can take approval like that, right? So this is allowed by sending these drafts to the directors and taking their approval. So resolution by circulation is passed when the details of the resolution to be passed are drafted and sent to the registered address of the directors and their approval is taken. And as per section 176 of the Companies Act 2013, the action or decisions taken by the director when he was in office would not become invalid just because it was subsequently noticed that his appointment was invalid by the reason of any defect or disqualification. So basically, if a director has done some work and after that it was found that his appointment was actually defective or that he was disqualified from becoming a director, so his actions, his work which he has already done, that is not going to be invalidated just because his appointment is found to be defective, right? But any work, any action that he takes after he knows that he has been disqualified or after he knows that his appointment is defective, so any such work he does after that, they are not going to be given the validity which has been given under section 176. I hope you are clear with this also. Moving on, question number 5. Minimum age for a director to become eligible to be appointed as a managing director, manager or a whole-time director is, so the answer to this question is B, that is 21 years. So now we will be dealing with the managing director, manager and the whole-time director. No company shall appoint or employ at the same time a managing director and a manager. So you have to understand that why this is written. So if you go through the Companies Act, if you read section 2 clause 53 and section 2 clause 54, the terms manager and the managing director, they have been defined. So by reading those, this becomes clear that why they have written this. So basically, the work, the functions, the duties of a manager and a managing director are substantially the same. Both of them, they have been given the duty that they have to manage the affairs of the company, either the whole of the company or the substantial portion of that company, right? So both of them, they are doing the same thing. They are doing what? They are managing the affairs of the company. So their work is to manage the affairs of the company. They are appointed in a different manner. They administratively have different status, but they are substantially performing the same function. That is why they have written that no company shall appoint or employ at the same time a managing director and a manager, because their work is same. Since their work is same, since they are doing the same duties, so we cannot have two people, we cannot have two employees doing the same thing, right? So no company shall appoint or employ at the same time a managing director and a manager. No company shall appoint or reappoint any person as its managing director, whole-time director or a manager for a term exceeding 5 years at a time. So maximum they can be appointed for 5 years at a time, right? A whole-time director, it has been defined in section 2 clause 94. Whole-time director is a director who is in whole-time employment of the company, right? So no company shall appoint or reappoint any person as its managing director, whole-time director or a manager for a term exceeding 5 years at a time. So at a time you can only employ them, you can only appoint them for 5 years. provided that no reappointment shall be made earlier than 1 year before the expiry of his term. So basically they are saying that if you have to reappoint a whole-time director, for example, in that case you can only make that reappointment during that last year. Let's just take an example. For example, a whole-time director has been appointed in the year 2016. So his term will be 2016, 17, 18, 19 and 20. In the year 2020 only you can reappoint him and not earlier than that, right? So provided that no reappointment shall be made earlier than 1 year before the expiry of his term. No company shall appoint or constitute the employment of any person as a managing director, whole-time director or a manager who is below the age of 21 years or has attained the age of 70 years. So the minimum age required is 21 years and the maximum is 70 years. So a person who is below the age of 21 years, he cannot become a director, a whole-time director, a managing director or a manager, right? Okay, moving on. Provided that the appointment of a person who has attained the age of 70 years may be made by passing a special resolution, in which case the explanatory statement annexed to the notice for such motion shall indicate the justification for appointing such person. But for example, there is a person who is 71 years of age and you know that he is going to be very beneficial for your company and you want to appoint him as your managing director. In that case, that company can do what? It can pass a special resolution by 75%. It can pass that special resolution and they can appoint such person, but they have to annex the explanatory statement that why you are doing so. So you have to explain that, you have to give that explanatory statement with the notice to the meeting, right? So provided that the appointment of a person who has attained the age of 70 years may be made by passing a special resolution, in which case the explanatory statement annexed to the notice for such motion shall indicate the justification for appointing such person. Provided further that where no such special resolution is passed but votes cast in favour of the motion exceed the votes, if any, cast against the motion and the central government is satisfied on an application made by the board that such appointment is most beneficial to the company, the appointment of the person who has attained the age of 70 years may be made. So basically now what is happening here, that you try to pass this special resolution, you try to get the 75% of votes, but you could not reach the 75% of vote, but in totality the number of votes that were in favor of that 71 years age person, the votes in favor of him, they were more than the votes which were against him becoming the managing director. In that case, what the company can do is, the company can make an application to the central government, and if the central government is satisfied that yes, this appointment, this is going to be beneficial for the company, in that case it can pass that order, right? So provided further that where no such resolution, special resolution is passed, but the votes cast in favor of the motion exceeds the votes, if any, cast against the motion. So the votes in favor, they are more than the votes that are against that person, then the central government is satisfied on an application made by the board that such appointment is most beneficial of the company, the appointment of the person who has attained the age of 70 years may be made. Is an undischarged insolvent or has at any time been adjudged as an insolvent, has at any time suspended payments to his creditors, or makes or has at any time made a composition with them, or he at any time been convicted by a court of an offence and sentenced for a period of more than 6 months. So if he has been convicted and he has been sentenced for more than 6 months, in that case he cannot become a director. So I hope you are clear with all these questions. Please make sure that you go through these questions and you read these sections, right? Moving on, question number 7. NCLAT is the appellate tribunal for hearing orders passed by. So the answer to this question is D, that is all of these. NCLAT, that is the National Companies Law Appellate Tribunal, is the appellate tribunal for hearing appeals against the orders passed by the Insolvency and Bankruptcy Board of India under section 202 and section 211 of IBC. This we have already done. NCLAT is also the appellate tribunal to hear and dispose of the appeals against orders passed by the Competition Commission of India under section 53N of the Competition Act. NCLAT is also the appellate tribunal for orders passed by the NFRA, that is the National Financing Reporting Authority. Question number 8. As per section 421(3) of the Companies Act 2013, appeal against the orders of the NCLT can be filed with NCLAT in how many days of the orders being received by the person assuming no exceptional grace period. So the answer to this question is C, that is 45 days. Section 421. Any person who is aggrieved by an order of the tribunal may prefer an appeal to the appellate tribunal. No appeal shall lie to the appellate tribunal from an order made by the tribunal with the consent of the parties. So since an order has been passed by the tribunal by the consent of both the parties, in that case appeal does not lie. So this we also read in CPC when we were dealing with the consent decrees, right? So because both the parties, they were in agreement, they consented to that thing, they consented to those conditions. In that case, any of these parties, they cannot be allowed to prefer an appeal, they cannot file an appeal, right? So no appeal shall lie in the appellate tribunal from an order made by the tribunal with the consent of the parties. Every appeal under subsection 1 shall be filed within a period of 45 days from the date on which a copy of the order of the tribunal is made available to the person aggrieved and shall be in such form as accompanied by such fee as may be prescribed. So the period of limitation is 45. If you have to move from NCLT to NCLAT, in that case the period provided to you is 45 days. Provided that the appellate tribunal may entertain an appeal after the expiry of the said period of 45 days from the date aforesaid, but within a further period not exceeding 45 days, if it is satisfied that the appellate was prevented by the sufficient cause from filing the appeal within that period. So basically another period of 45 days, not exceeding 45 days, it can be granted to an appellant if he has a genuine reason that he could not file his appeal within the given 45 days, right? On the receipt of the appeal under subsection 1, the appellate tribunal shall, after giving the parties to the appeal a reasonable opportunity of being heard, so this is obvious, pass such order thereupon as it thinks fit. Either what they can do, they can confirm the order of the NCLT, or it can modify it, or altogether it can set aside the order that was passed by the NCLT. The appellate tribunal shall send a copy of every order made by it to the tribunal and the parties to the appeal. So the order, it has to be sent to the NCLT and to the parties to the appeal, right? Alright, moving on, question number 9. Which of the following is minimum qualification for a person to be appointed as a president of NCLT? So the answer to this question is A, that is Judge of the High Court for 5 years. Qualification of the president and members of the tribunal. The president shall be a person who is or has been a judge of the High Court for 5 years. So in NCLT we have a president and in NCLAT we have a chairman, right? Here we are talking about the qualification of the president of NCLT. So the president shall be a person who is or has been a judge of a High Court for 5 years. A person shall not be qualified for appointment as a judicial member unless he is or has been a judge of the High Court, is or has been a district judge for at least 5 years, or has for at least 10 years been an advocate of a court. So these are the qualifications of a judicial member. In NCLT there are judicial and technical members apart from the president. So in NCLT there is a president and other judicial and technical members as the number may be prescribed, right? So these are the qualifications of the president and the judicial members. Alright, moving on, question number 10. As per section 422 of the Companies Act 2013, if appeal is not disposed within 3 months, then NCLT and NCLAT shall record the reasons for not disposing within 3 months. The president in case of NCLT and the chairman in case of NCLAT can extend the timeline to dispose the appeal by a maximum of dash days after reading the reason. So the answer to this question is D, that is 90 days. Let's read this. Every application or petition presented before the tribunal and every appeal filed before the appellate tribunal. So in case of NCLT it is going to be an application or a petition, and in case of NCLAT it is going to be an appeal, right? So every such application, every such appeal, it shall be dealt with and disposed of by it as expeditiously as possible, and every endeavour shall be made by the tribunal or the appellate tribunal, as the case may be, for the disposal of such application or petition or appeal within 3 months. So the endeavour is made that this appeal or application, it has to be disposed within 3 months from the dates of its presentation before the tribunal or the filing of the appeal before the appellate tribunal. Where Any application or petition or appeal is not disposed of within the period specified in subsection 1, the tribunal, or as the case may be the appellate tribunal, shall record the reasons. In that case, they have to record it for not disposing of the application or petition or appeal, as the case may be, within the period so specified, and the president or the chairman. So president in case of NCLT and chairman in case of NCLAT, as the case may be, may, after taking into account the reasons to record, extend the period referred to in subsection 1 by such period not exceeding 90 days as he may consider necessary. So not more than 90 days period can be extended, right? So period not exceeding 90 days as he may consider necessary. So maximum of 90 days they can be given. Alright, moving on, question number 11. As per section 423 of the Companies Act 2013, any person aggrieved by any order of the appellate tribunal can file an appeal to the Supreme Court within dash days from the date of receipt of the order of the appellate tribunal by him. So the answer to this question is C, that is 60 days, right? So if you are moving from NCLT to NCLAT, in that case 45 days period has been given, and in case you are moving from NCLAT to the Supreme Court, in that case 60 days period has been provided, right? So any person aggrieved by any order by any order of the appellate tribunal may file an appeal to the Supreme Court within 60 days from the date of the receipt of the order of the appellate tribunal to him on any question of law arising out of such order, provided that the Supreme Court may, if it is satisfied that the appellate was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a further period of not exceeding 60 days. So in the same manner, if the Supreme Court is also of the opinion that the appellate, he was actually prevented by a cause, he had a genuine reason for not filing the appeal within 60 days, then he can be given another 60 days time period, right? Question number 12. What is the maximum years of imprisonment a special court can sentence while try in a summary way any offence under this act which is punishable with imprisonment for a term not exceeding 3 years? So the answer to this question is A, that is 1 year, right? Let's read it. Notwithstanding anything contained in the Code of Criminal Procedure, a special court may, if it thinks fit, try in a summary way any offence under this act which is punishable with imprisonment for a term not exceeding 3 years. So if an offence is punishable with a term which does not exceed 3 years, in that case, that trial, it can be held in a summary way, provided that in case of any conviction in a summary trial, no sentence of imprisonment for a term exceeding 1 year shall be passed. And if a trial is being conducted in a summary way, in that case more than 1 years of sentence it cannot be granted, provided further that when at the commencement of or in the course of the summary trial, it appears to the special court that the nature of the case is such that the sentence of imprisonment for a term exceeding 1 year may have to be passed, or that it is for any other reason undesirable to try the case summarily, the special court shall, after hearing the parties, record an order to that effect and thereafter recall any witness who may have been examined and proceed to hear or rehear the case in accordance with the procedure for the regular trial. So basically, if during the course of the trial or during the commencement of the trial, it is found by the special court that this is a difficult case, for example, and more than 1 years of punishment has to be given in this case, or due to any other reason the court is of the opinion that this case that cannot be tried in a summary way, in that case they will record that reason, they will make that effect, and they can try that suit in a regular way, and any of the witnesses that have already given the evidence to the court, they will be recalled and they will give their evidence again, right? So this is question number 12. Moving on, question number 13. Compounding may be done in case of offences punishable by, the answer is A, that is fine only. Notwithstanding anything contained in the Code of Criminal Procedure, any offence punishable under this act, whether committed by a company or any officer thereof, not being an offence punishable with the imprisonment only, or punishable with imprisonment and also with fine, may either before or after the institution of any prosecution be compounded by. So which are the offences which can be compounded under this act? The offences which are punishable with fine only, offences which are punishable with fine or imprisonment, or the offences which are punishable with fine or imprisonment, or both, right? So there are 3 types of offences which can be compounded under the Companies Act. These are if it is punishable with fine only, or if it is punishable with imprisonment or fine, or if it is punishable with imprisonment or fine, or both, right? the tribunal, or where the maximum amount of the fine which may be imposed for such offence does not exceed 25 lakh rupees by regional director. So who are the compounding authorities here? There are two authorities which have been given this power. It is the tribunal itself, and the second one is the regional director. In case the fine to the offence is less than 25 lakh rupees, then it will be dealt by the regional director, otherwise it will be dealt by the tribunal, right? So where the maximum amount of fine which may be imposed for such offence does not exceed 25 lakh rupees, then it will be dealt by the regional director, or any offence authorized by the central government on payment or credit by the company, or as the case may be, the officer to the central government of such sum as the tribunal or the regional director or any officer authorized by the central government as the case may specify, provided that the sum so specified shall not in any case exceed the maximum amount of the fine which may be imposed for the offence so compounded. So basically the amount that you are giving to compound the offence, that cannot exceed the maximum amount that has been prescribed as a fine for that offence, right? So provided that the sum so specified shall not in any case exceed the maximum amount of fine which may be imposed for the offence so compounded. Provided further that in specifying the sum required to be paid or credited for the compounding of an offence under this subsection, the sum, if any, paid by the way of additional fee under subsection 2 of section 403 shall be taken into account. Provided also that any offence covered under this subsection by any company or its officer shall not be compounded if the investigation against such company has been initiated or is pending under this act. So basically, if investigation is pending before a company or it has been initiated, in that case no compounding of offence can take place. I hope you are clear with this question also. Moving on, question number 14. Who shall maintain the mediation and conciliation panel? So the answer to this is B, that is the central government. The central government shall maintain a panel of experts to be called as a mediation and conciliation panel. Alright, last question, question number 15. Which of the following statement are correct? The central government or the tribunal or the appellate tribunal before which any proceeding is pending may suo motu refer any matter to the mediation and conciliation panel. Any party aggrieved by the recommendations of the mediation and conciliation panel may file objections to the central government or the tribunal or the appellate tribunal. The mediation and conciliation panel shall and dispose of the matters referred to it within a period of 6 months from the date of such reference and forward its recommendation to the central government or the tribunal or the appellate tribunal. So the right answer to this question is that first and second statement, they are correct. But the third statement is actually wrong. In the third statement, the time period should have been 3 months, not 6 months, right? So let's read this. The mediation and conciliation panel shall and dispose of the matters referred to it within a period of 3 months. It should have been 3 months from the date of such reference and forward its recommendations to the central government or the tribunal or the appellate tribunal, right? So the answer is D, that is only first and the second statement they are correct, but in the third statement it should have been 3 months. Alright, now question for achievers. In case there are more than one special courts of any area, which one of them will try the offences? The oldest court of the region, the court with the senior most judge, the court as specified by the High Court, the court with the highest number of the judicial members. So you have to comment the right answer below. Alright, so that was all for today. I hope it was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.